in it. And I wanted to make sure this film always had a female gaze, and I was never putting myself into it. But one of the things that I think is very easy to say, especially
Blake Lively, the Stoob star who keeps delivering lies, misrepresentation, and toxicity, continues to fuel the "it ends with us" saga. Honestly, I thank her for it. This drama clearly isn't taking a holiday break, and neither am I. Hello, my friend. It's Paris, the queen of all media, the original influencer and still your #1 source for everything surrounding the "it ends with us" controversy. As previously reported, Team Lively filed yet another motion for sanctions, this time targeting the Wayfarer and Baldoni attorneys. They claimed the lawyers behaved inappropriately during depositions, accusing them of delay tactics, improper objections, and even questioning that Blake Lively believes crossed personal boundaries. But now, Team Wayfarer has officially responded and they're setting the record straight. The so-called mistress of misrepresentation, surrounded by like-minded lawyers, is once again being called out. According to Kevin Fritz, who is clearly billing overtime, these accusations simply don't hold up. In a formal response addressed to Judge Lyman, Fritz writes on behalf of Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sorowitz, It Ends with US Movie LLC, Melissa Nathan, The Agency Group LLC, and Jennifer Abel, collectively known as the Wayfarer, parties firmly opposing Blake Lively's motion for sanctions and any additional relief tied to the deposition of Nicole Alexander. We now know exactly who Nicole Alexander is and what she does. As I previously shared, her deposition last Monday is what triggered that emergency phone call with Judge Lyman. Alexander is an expert in digital ecosystems, AI-mediated brand perception, and online reputation measurement. She was designated by the Wayfarer parties to rebut expert claims suggesting that social media activity involving Blake Lively from August 2024 through February 2025 resulted from a coordinated negative manipulation campaign, as Lively alleges, rather than organic public engagement and standard entertainment media cycles. On December 15, 2025, Nicole Alexander was deposed for 7 hours, with questioning led by Blake Lively's counsel, Meryl Govney, focusing heavily on her expertise and expert report. Yes, this is the same Meryl Govney I personally went head-to-head with in Las Vegas. Boom bang bow bing. Interestingly, Fritz includes a footnote addressing one of the more explosive claims. Despite allegations suggesting inappropriate questioning, he states clearly that Alexander's deposition had absolutely nothing to do with Blake Lively's sexual or romantic history, directly contradicting the narrative Lively's team is trying to push. Nonetheless, the motion relies on a self-serving letter from 3 months ago, which immediately raises questions. The letter, sent by Blake Lively's counsel to the Wayfarer party's counsel, complains incorrectly about certain deposition questions that were supposedly related to her sexual or romantic history. In reality, the questions at issue concerned Blake Lively's reputation, an issue she herself placed squarely before the court. Notably, she never sought court intervention at the time regarding any allegedly improper questioning, nor is she seeking such relief now. Instead, this motion appears to have been filed for one purpose only: to generate inflammatory headlines and falsely smear the character of the Wayfarer party's counsel. To drive that point home, Fritz even attached media headlines from Variety and Page 6 as receipts. Turning back to Fritz's substantive opposition to the sanctions request, he points directly to the Federal Rules of Civil Procedure. Rule 30C2 requires that objections during a deposition be stated concisely and in a non-suggestive manner, while Rule 30D2 allows courts to impose sanctions only when conduct actually impedes, delays, or frustrates a fair examination of the witness. According to Fritz, none of that happened here. Blake Lively submitted only 35 pages of Nicole Alexander's deposition transcript, 10% of the total, apparently in an effort to construct a misleading narrative. In response, the Wayfarer party submitted the entire transcript so the court could see the full context, even if it meant giving the court clerk, not the judge, significantly more work. A complete review of the transcript, Fritz argues, makes clear that Alexander's deposition was not impeded, delayed, or frustrated in any way. The Wayfarer party's counsel objected concisely and appropriately to the form of certain questions, did not engage in speaking objections, and allowed Alexander to answer every question except for a single topic, which is addressed separately. Crucially, the motion fails to identify any meaningful area of testimony that Blake Lively's counsel was prevented from exploring due to objections. What Lively labels as frequent speaking objections is revealed, upon review, to be trivial. Although she claims the Wayfarer party's counsel improperly interrupted the deposition to ask whether Alexander should review an exhibit, The cited examples tell a different story. They show that Lively's counsel, Meryl Ganiski, was unaware that Alexander had amended her expert report and mistakenly asserted that the amended report had never been served, despite the fact that it had been provided a month earlier. The Wayfarer party's counsel simply and professionally corrected the record and guided her in the right direction. Miss Alexander, who had never been deposed in any litigation before, let alone in a remote setting, was advised to download the exhibits so she could review the entire document, just as she would during an in-person deposition, rather than being limited to only the portions visible through Meryl Ganiski's screen sharing. And then there's Miss Ganiski herself. This entire issue is frankly unnecessary. She asked Miss Alexander to summarize a lengthy article cited in the expert report, which understandably confused the witness as to whether she was being asked to recall it from memory or review it again. When the Wayfarer party's counsel sought clarification on that point, Meryl Governey responded not by clarifying the request, but by launching into a tirade. The transcript makes this clear. Governey asked whether Miss Alexander could summarize the contents of the paper. Fritz objected, and the witness explained she could not do so offhand. Fritz then asked whether counsel wanted the witness to read the entire article. Governey said no, insisting that Alexander should already know it because she cited it multiple times in her report. Fritz again clarified whether the witness should read it first, and Governey again said no. When Alexander was finally able to respond, she offered a concise explanation, stating that the article focused on coordinated networks and the tools used by the authors to identify them. When Governey pressed for specific tools named in the article, Alexander stated she did not recall them offhand. Further questions followed about definitions of coordinated behavior on social media, to which Alexander explained she would need to reread the paper. At that point, Governey abruptly ended the line of questioning. To be fair, and I like to be honest, this was actually a smart line of questioning from Meryl. It was well thought out and strategically sound. Credit where it's due. Returning to Fritz's opposition to the sanctions request, he notes that during one exchange cited in the motion, Miss Ganiski interrupted a witness who was clearly confused by the questioning. The Wayfarer party's counsel simply suggested that Ganiski listened to the witness so the questions could be properly clarified. Fritz also points out a critical omission at the start of the deposition. Ganiski failed to provide the standard instruction that, if the witness did not understand a question, she should say so and counsel would rephrase it. As for Blake Lively's criticism that Miss Alexander was occasionally instructed to answer again, Fritz makes clear that such direction is not improper under deposition rules. And honestly, this is why I love reading every filing, because buried in each one are little gems that completely undercut the narrative being pushed. Examples of truly improper speaking objections, Fritz notes, can be found not in this deposition at all, but in those made by Blake Lively's counsel Ezra Hudson during the deposition of non-party Jenny Slate. Naturally, that raises questions I want to know more, and I need to know more, but unfortunately, the excerpts from Jenny Slate's deposition were filed under seal. Convenient, Fritz goes on to point out. Another basic procedural failure. Miss Governey never instructed Miss Alexander at the outset of the deposition that she could request a break, which is standard practice. Despite that, Blake Lively inexplicably took issue with a simple suggestion made after 2 hours of questioning that Miss Alexander and the stenographer be given a break. When Miss Alexander's counsel formally requested that break, Miss Governey proceeded to ask yet another question and then attempted to use the claim of a pending question as a reason to deny the break altogether. That argument collapsed when the stenographer confirmed that no question had, in fact, been pending. Overall, the questioning of Miss Alexander proceeded relatively smoothly, particularly after counsel conferred with the court during a break. Crucially, Blake Lively failed to demonstrate that the deposition was impeded, delayed, or frustrated in any meaningful or substantive way. Fritz then cites the governing rule directly. A person may instruct a deponent not to answer only when necessary to preserve a privilege. In this case, the only time Miss Alexander was instructed not to answer was based on privilege and work product protections, specifically in connection with questions about her conversations with separate counsel, conversations for which she could not even recall the identities of the attorneys involved. Rather than accepting that instruction, Miss Governey improperly attempted to debate opposing counsel during the deposition itself. The transcript reflects this clearly. As Miss Alexander discussed a prior conversation with attorneys, Governey asked whether Alexander had ever spoken with any of those individuals before. The witness answered no. Governey then followed up by asking whether Alexander understood that those attorneys were speaking with multiple individuals as part of a vetting process. At that point, Fritz reiterated the instruction, stating that to the extent any answer would require disclosure of the substance of a privileged conversation, the witness was instructed not to answer. And once again, the record shows that the instruction was proper: no obstruction, no gamesmanship, just adherence to the rules. The exchange escalated when Meryl asked the expert whether she was following her counsel's instruction not to answer, to which the expert replied yes. Meryl then stated that going forward, the witness would always follow Fritz's instructions not to answer and demanded that Fritz articulate the basis for those instructions. At that point, Brian Friedman interjected, asking that the speaking objections stop. Fritz responded that he did not know who Friedman was, prompting clarification that he was, in fact, Brian Friedman. Merrill pushed back, pointing out that Friedman had not entered an appearance in the deposition and instructing him to stop making speaking objections. Merrill made it clear she was not backing down, stating flatly, "It's my deposition." Friedman fired back just as bluntly, telling her she was improperly handling the deposition and accusing her of not knowing how to practice law, again demanding that she stop with the speaking objections. Merrill responded by asking that Friedman be muted, reiterating that he had not entered an appearance and insisting that she was not giving speaking objections. She accused Friedman of being the one engaging in speaking objections, noting that he was actively talking. Merrill then turned to Fritz, asking him to control his co-counsel or else she would seek relief from the court. Fritz responded candidly, stating that Friedman was not wrong and that Merrill appeared to be trying to engage in argument. Amid the crosstalk, Merrill insisted she was simply trying to understand the basis for the privilege objection and asked Fritz to explain where he believed the line on privilege was drawn. After that moment, Friedman ceased participating in the exchange. Fritz then continued his opposition to the sanctions motion, arguing that Blake Lively's counsel violated Rule 4C of the court's individual practices by failing to meet and confer, after the deposition or even during a break, the propriety of the objections. He asserted that the motion should be denied on that basis alone. Fritz explained that had Lively's counsel followed the court's procedures for resolving discovery disputes, the parties would have agreed to a brief continuation of Miss Alexander's deposition by remote means, scheduled at a mutually convenient time, and narrowly limited to questions about her communications with separate counsel, including the facts or data those attorneys provided that informed her expert opinions. Fritz stated that the Wayfarer parties are now willing to stipulate to that limited continuation. Finally, Fritz characterized the motion to sanction Brian Friedman and himself as frivolous, noting that it relies on allegations of an ongoing pattern of deposition misconduct while citing no prior misconduct by either attorney in any deposition whatsoever. There is also a telling footnote tucked into the filing, which explains that the citations to Jamie Heath's deposition transcript relate to an entirely different situation. In that instance, counsel was not responding to any pending question at all, but was instead raising concerns about the lengthy breaks Blake Lively's counsel was taking during the deposition. That clarification alone undercuts the attempt to lump unrelated conduct into this sanctions argument. Returning to Fritz's opposition, he points out that the cases cited by Blake Lively involve extreme and clearly distinguishable conduct situations where attorneys deliberately violated repeated court orders, engaged in prolonged and unnecessary arguments over the relevance of straightforward questions, instructed witnesses not to answer based on relevance alone, or were held accountable for a client's failure to comply with document production orders. Fritz notes that Miss Lively does not allege, let alone demonstrate, that either Brian Friedman or he engaged in any such behavior. According to Fritz, the only real ongoing pattern here is Blake Lively's repeated use of the media to disparage others and divert attention